start with our next MCQ question of CA Final Law Paper 4 from the ICA booklet. Question states, due to the non-compliance of certain requirements under the Companies Act 2013, not amounting to fraud, Sika Supermarket Limited was required to restate its financial statements for the financial year 17-18 during the current year. After the financial statements were restated, it was found that Mr. Kumar, the managing director of that period, who is now retired, was paid excess remuneration to the extent of 5 lakhs. In the given situation, choose the correct option out of those given below, which indicates whether excess remuneration paid to ex-MD, Mr. Kumar, is recoverable or not. Now let's look at the provision and get back to our question. So here comes the recovery of managerial remuneration in certain cases. So what could be the certain cases means where a company is required to restate its financial statements for any period due to fraud or non-compliance with any requirement under the Companies Act 2013 and their rules. The company will recover from any past or present MD or the WTD or manager or CEO who received the excess remuneration, including stock option, during the period for which the financial statements are required to be restated. So the flowchart is very clear that this can be recovered, whether it is from past MD or the current MD. So below the flowchart it states the excess remuneration to be recovered shall be the difference between the actual amount of remuneration received by such person and the remuneration that would have been payable to him as per the restatement of financial statement. So the recoverable amount would be the difference amount. Let's go back to our question. So the question states excess remuneration is to the extent of 5 lakhs. Now let's look at our options. Excess remuneration of 5 lakhs paid to Mr. Kumar, ex-MD of Sika Private Supermarket Limited, cannot be recovered. Is that so? No, it can be recovered. So option A is incorrect. Option B says excess remuneration of 5 lakhs paid to Mr. Kumar, ex-MD of Sika Supermarket Limited, shall be recovered irrespective of his retirement from the company. Yes, this is the correct option. Even if you are a past MD, that can be recovered. So option B is the correct option. So option C and option D is saying only a part percentage of 50 or 25% of the excess remuneration can be recovered. So that cannot be your answer, because the entire amount can be recovered irrespective of whether you are the current director or the past director. Following to the next question, the Board of Directors of Capable Hospitality Services Limited has entrusted Mr. Vikas, the newly appointed managing director of the company, with some powers. However, Mr. Vikas is not interested in discharging administrative functions as authorized by the Board of Directors, since he is of the view that he should not have been entrusted with substantial powers of management. Out of the following 4 options, which one is correctly applicable in relation to the functions of Mr. Vikas, the MD of Capable Hospitality Limited, can undertake? Now let's look at the functions that can be entrusted to a managing director from our ICA material. So here comes our explanation to section 2 subsection 54, which clarifies the substantial powers of management shall not be deemed to have include the power to do such administrative task of routine's nature when so authorized by the board as such. So these activities are excluded. I mean, you can't exercise these activities. So what were the activities? The power to affix a common seal of a company to any document, to draw or endorse any check on the account of the company in any bank, to draw or endorse any negotiable instrument, to sign any certificate of share, to direct registration of transfer of any share. Thus, excluding the above administrative activities of routine nature, the managing director enjoys the substantial powers of conducting and managing the business of company as per its memorandum and articles of association. So these 5 activities these activities shall not be taken by a managing director. Now let's go back to our question. So looking at the options, option says to draw or endorse any check on the account of a Capable Hospitality Services Limited maintained with National Commercial Bank Limited, the main banker of the company. So drawing and endorsing any check on the account of a company is excluded from the substantial powers. Henceforth, option A is incorrect. Option B states to sign the financial statements of Capable Hospitality Limited Yes, it is not included in the exclusion list. Henceforth, this can be the substantial power that Mr. Vikas can undertake. So option C and option D states to endorse any bills of exchange which exceeds 1 lakh and 5 lakhs respectively, and that is being excluded from the substantial powers. If at all you want, you can go back and look at the substantial powers. So here you have drawing and endorsing any check on the account of the company, and drawing and endorsing any negotiable instrument. Both of things have been prohibited, but you don't have any statement where signing of financial statements is prohibited. Therefore, option B is the correct option. So now we'll move on to the next question. Mr. Joseph Daniel, holding the office of full-time director in Tasty Choco Chips Limited, is desirous of appointing Mr. Vanilla, who has attained the age of 72 years old, as a managing director of the company. However, the board of directors is of the opinion that no company shall appoint or continue the employment of any person as managing director, full-time director, or a manager who is below the age of 21 years or has attained the age of 70 years. From the following four options, select the one which is applicable in relation to the validity and invalidity of appointing Mr. Vanilla as a managing director of Tasty Choco Chips Limited. Now let's go back and look at the provision first before we jump into the answers. So here comes our question, our provision. So eligibility conditions for appointment. Look at the first side heading, requirement of special resolution for appointment of a person above the age of 70 years. There is a relaxation in case of a person above the age of 70 years. Accordingly, where a person has attained the age of 70 years, he may still be appointed to such office if a special resolution is passed in this respect. In such a case, the explanatory statement annexed to the notice for such motion shall indicate the justification for appointing such person. So if you have a special resolution being passed, you can still appoint a person who is above the age of 70. Now let's go back to our options given. So option A states, in spite of the fact that Mr. Vanilla has attained the age of 72 years, he can be validly appointed as a managing director of the board of directors of Tasty Choco Chips Limited when the recommendation has been made by Mr. Joseph, the whole time director. Is that so? Just recommendation doesn't work. You need a special resolution being passed. So option A is incorrect. Since Mr. Vanilla has attained the age of 72, he cannot be validly appointed. Is that so? No, he can be appointed by passing a special resolution. So option B is also incorrect. Option C states, in spite of the fact that Mr. Vanilla has attained the age of 72, he can be validly appointed as a managing director by the shareholders of Tasty Choco Chips Limited through passing a special resolution in general meeting. Yes, this is what we are looking for, right? So option C is the correct option. Option D states, in spite of the fact that Mr. Vanilla has attained the age of 72, he can be validly appointed as a managing director if an application is made to the NCLT and its permission is received. So there is no concept of NCLT being involved in the provisions. Therefore, option C is the correct option. We'll move on to the next question. On June 20, 2017, Mr. Anil Mehra was appointed as a manager of PQR Music Systems Limited for a period of 5 years. Considering his performance and dedication towards the company, the management of PQR Music Systems Limited decided to reappoint him as a manager before the completion of his tenure. Out of the following four options, choose the one which indicates the date on which his reappointment can be considered valid. So now let's look at the provisions which states the reappointment. So here comes our tenure. No company shall appoint or reappoint any person as its managing director, whole-time director, or manager for a period exceeding 5 years at a time. It is further provided that no reappointment shall be made earlier than 1 year before the expiry of his term. So you can only make reappointment in the 4th year of the total tenure of 5 years. Now let's go back and see the options. So Mr. Anil was first appointed in 2017 June 20, right? From there you have to count 4 years a minimum, because his term expires in 5 years. So if you count it, 2018, 2019, 2020, 2021, 2022. So by June 2022, his period of 5 years ends. So reappointment can be made only in post June 2021. Correct? So now let's look at the options and see whichever falls in that criteria. So the first option states June 24, 2021. Yes, this is in the last year of his tenure, which so henceforth this can be a valid date of reappointment. So option A is the correct option, but let's look at the other options as well. So February 20, so the other three options were falling below the fifth year. Like it's not coming in the last 1 year time span. 20 any appointment can be made post June 2021. So these dates are falling before that date, henceforth these cannot be a valid or a correct answer. Now let's look at the 15th question. Lockwood Safety Gears Limited, which pays remuneration to its directors on a yearly basis, has Harsha as whole-time director. Recently, the company appointed Mr. Ravi Ansh as managing director. While paying remuneration, Locksmith Safety Gears Limited needs to keep in view that the overall remuneration payable to the directors, including managing director and whole-time director and manager, shall not exceed the maximum limit prescribed under the relevant provisions. After the appointment of Ravi Ansh as managing director, since the company has both whole-time director as well as a managing director, select the appropriate option from those given below, which indicates the maximum remuneration that is allowed in a financial year. So here you have two. Here this company has both whole-time director and the managing director. Now let's look at the table given in our ICS study material to see what's the maximum remuneration percentage. So here if we look at the third point, if there is more than one managing director or whole-time director or a manager, that is the remuneration payable to all such managing director, whole-time director, manager taken together should be the 10% of the net profits of the company for that financial year. The limit of 10% may be exceeded with the approval of the company in a general meeting by passing a special resolution. So the maximum limit is 10% of net profits. If you want to exceed that, you have to pass a special resolution. Now let's go back and see the final answer for this question. So option A says 3. So the final answer would be C, 10% of net profits. Option A, B and D are invalid. They are incorrect answers. This is a straightaway rule out from the provision. So 10% of net profits. With this, we have completed the first 15 MCQ questions. Hope these videos are helpful to you. Please do like, share and subscribe to the channel to get the latest updates of the videos. Share it with your friends to help them to complete the revision very fast. Thank you for watching.